All right, good afternoon, everyone. Thank you for joining us today. My name's Kayleigh Swift. I'm the Director at NB Property Law, and we've got Damian Ebzery from Tax Advisory Strategist. So today we're here to talk about smart ownership, so structuring employee share schemes and the shareholder agreements. So to begin with, I'll just introduce myself and who we are at NB Property Law. So we offer personalised, proactive advice to help minimise risk and take the stress out of your next property transaction or estate planning matter. We're more than just a team of legal experts. We're dedicated problem solvers committed to creating personalised solutions to guide you forward. Whether it be from residential to commercial property law concerns, we're here to provide the clarity and guidance you need. And I'll hand over to Damian now to introduce himself.
Hi, everyone. Damian Ebzery here. So I'm a registered tax agent, and I've had a background in financial advisory as well over the last 20 years, and dropped that off in June 2020. But the reason why I changed was noticed that there was a need for niche small business tax advisory and structuring advice that wasn't being really serviced well out in the marketplace. And part of that with structures and companies is, of course, the shareholder agreements. So often Kayleigh decided that this would be a good topic that's often overlooked or undercooked. So looking forward to shedding some light on some things you need to consider.
Wonderful. Thanks for that, Damian. So our agenda today, what we're going to go through is employee share schemes and the tax benefits. So talking about how to structure employee incentives while optimising the tax outcomes. We'll go through, what is shareholder agreements and how to use them for asset protection. So talking about safeguarding your business interests and managing the disputes and how to actually plan for exits. We'll go through understanding the different types of agreements that are available and look at the key considerations for structuring ownerships effectively. And the last thing that we're going to touch on is employee share schemes. So what are the pros and cons of them and how do we evaluate those benefits and the potential risks involved in using them? So we'll start with you, Damon, talking about the shareholder agreements, if you like.
Yeah. So broadly speaking, there's two types of shareholder agreements that we generally look at. One is where you're actually wanting to bring other partners into your business. So basically issuing shares to someone other than under your own control to bring in new partners, which is a bit different to employee share schemes and offerings because there's different things to consider in those zones. So the business partner agreements are at a different level and require different considerations. I think we enter into a few of those considerations on the next slide. So with business partner agreements, A is, okay, you've got a company, you've got shares in the company, you're going to have a couple of background documents to that, which go into more depth later on, but usually a share constitution, a company constitution. Now, that determines how a company operates as such, but there's much more to it when you're looking at bringing in other partners into the business. First off is share issuings. Who are you going to allow to own shares and how are you going to allow them to own it? So, for instance, a lot of my structuring with clients, their business company shares would be owned through a discretionary trust. So those shares are actually controlled by the trustee of the discretionary trust. Now, who is that and who is involved with that? So I'll just be generic here. If my shares in my company are owned by my family trust, my wife's also a part controller of that trust. So from somebody coming in to invest in a business, they've got to understand that those shares aren't just controlled by the person you're going into business with, but somebody probably linked to them as well. So this is where the shareholder agreements really come into play, because if something happens and the person you're technically working each day with has some sort of situation occur, what happens to the control of their shares? and how does that affect the day-to-day trading of the company and operation of the company. And what we see too sometimes is, okay, you're starting up a company, how much cash capital is needed to start and operate the company, and who's going to be putting that in. Now, sometimes what we see is you might have a cash capital person putting in, but then you might have another person being involved that's more on the tools each day, and we call that the sweat equity. So early in business, you might not be paid as a employee. You might be putting the sweat equity into the business. So there has different valuation concepts on that sort of thing. But you need to also understand what is the role of each owner. Someone may be, a more like a silent investor versus somebody on the tools and being involved. And what does that mean to the business, and how does it operate? So down the track, you might also have situations where you've got two partners working in the business, and what do you have? How do you deal with issues where someone may be pulling their weight and someone may not be, and so forth? So there's all sorts of terms and rules and regs that go into these shareholder agreements to try to cover off what happens if this happens, what happens if that happens. And it's all good and dandy when you enter into a starting in the business. We call it the honeymoon period. Everyone's mates, everyone's excited. But you need to allow for the situations that may arise where not everyone does agree, and how do you go and deal with those sort of issues? So the other issue sometimes is what we call control of a company. Generally has two stages. One is what we call a company making ordinary resolutions. Usually that's a 50-50 thing. You need 50% plus one to control the company on those ordinary resolutions. And then there's special resolutions, which usually on most constitutions require 75% control to make a decision. So where you might have some investors being quite on a minority level, technically, do they really have any control in the business? But there are ASIC rules around minority shareholdings, but you don't want to have to be going to court to try to use those. So this is all these mechanisms that a good shareholder agreement should deal with, and what's the solutions for if problems arise. Some of the things I often see is issues where people haven't really documented anything on a shareholder agreement. Okay, if something happens to the health of one director, shareholder, or share controller, and they can't be in the business anymore. So that might be some sort of illness or injury. And what does that mean for the other part owners of the business? You don't really necessarily want the spouse or life partner of one of your business partners taking control of their shares. So most agreements would have a buy-sell trigger for these sort of circumstances. But if you have a buy-sell trigger, you need two other things to consider. One is, how does a business get valued? Now, I've seen all sorts of different valuations on businesses, depending on what the goal of the person asking for the valuation is. Often, if you're buying the shares off someone, you want the valuation to be as low as possible because you have to pay as little as possible for their shares. If you're selling, you want the highest possible valuation. So it's good to have agreements that actually dictate how these things occur, rather than be a bit of a fight at the time. And there may be different valuation methodologies as well. So, and that's probably more in the employee side. But if someone's played up and done the wrong thing, there might be a very low buyback price on those shares because they're the ones that have caused the trouble. The triggers can be wide and varied, but usually you see them around health and capacity. just wanting to get out, or there may be a scenario where the team can't decide or agree on the future direction of the business, and someone says, well, if I'm not going this way, I want out. So they're the sort of triggers that we see occur. And the other one is premature death. When somebody unfortunately dies early, how do we deal with that situation? So then we come to the funding of buyouts and buybacks, and depending on what the trigger is, there are various methodologies for this. There can be what we call buy-sell insurance. So for health and premature death related, there may be insurance policies properly documented and linked to a buy-sell part of this agreement where insurance premiums are paid, and if something happens, the payout from the insurer will properly documented will help fund the buy-sell of that person's share of the business. Because what can happen is a trigger comes along, but the rest of the owners of the company don't have sufficient cash to actually buy the person out, so we end up with a problem there. So you're trying to solve those solutions before you start. So that's, at a high level, there's all those sort of considerations that in a properly structured shareholder agreement that these would deal with, because there's so many things that can happen day to day in business that you need to consider. But it's the rule book to go to when shit hits the fan, sort of thing, because that's when you need some guidelines to help things occur. I might move on. So that's, the business partner agreements also cover some other, from a tax related issue, some other things for consideration. Now, you may or may not be aware that there's certain capital gains tax, small business owner concessions, depending on the size of the business. So, for instance, one may be the 15-year exemption. If you hold a share of business for over 15 years, you actually can sell it and have no capital gains tax on that sale of that part of the business. Then there's but these CGT exemptions relate to a certain portion of ownership of the business you must have at least, and it's generally around 20%. But the ownership and control and so forth has to be well thought out to ensure that the people can access these tax concessions. So there's a 15-year one, there's a retirement one, there's what we call an active asset one. So technically shares in a business company can be considered an active asset because the asset, the company, is actually doing a trading business. So some companies sell a business as a whole. They don't sell the shares in the business, they sell the business. That can have some different tax effects for the company itself. And then the shareholders, you have to look at a staged approach on how to benefit from these exemptions. And so it's not a one-size-fits-all arrangement, but these concessions need to be considered at the start when you're structuring ownership of a company. And even if it's a trigger along the way, for the seller, there may be some of these concessions available, even if it's an unplanned exit from the business. So it's important to think about these things any time that you either enter into a small business arrangement, exit or planning on exiting, and so forth. So there should always be a discussion had at the start. Dispute resolutions, probably more down Kayleigh's line, but what happens if you can't agree? And then the main one, which I've probably covered pretty well, is the mental capacity, illness and premature death. Because mental capacity if you're mental capacity impaired to a certain level, you're no longer allowed by ASIC laws, ASIC Corporations Act, to be a director of a company. So you may be automatically removed, which means what does that happen? How does that affect things? And it could happen at the higher level too, where the controller of your shares in the business or the trust that owns them, you can't be a director of the company you're working in, and you may not be able to be a director of and you won't be able to be a director of the entity that owns your shares. So it's a really important thing to consider, and there's some different strategies that can deal elsewise with this, and I'm pretty sure Kayleigh might cover off on things like company powers of attorney and enduring powers of attorney, as well as linking to these documents. But that's a separate bolt-on to these agreements in the first place. Anything you want to add on that, Kayleigh?
No, yeah, we'll talk about it a little bit later. But yeah, as you mentioned, the power of attorney documents are good in the situation that someone's lost their mental capacity for a period of time, and just allows them to appoint someone else to make those decisions on their behalf during that incapacity.
But the other owners and controllers of the business probably want to be comfortable with who that person may be as well, or understand who it is and so forth. So those sort of cards should be put on the table early as well. If something happens to me, this is who will step in and act for me. You, as the rest of the owners, need to be aware of that and be comfortable with it. So here we go. Employee shareholder agreements. They're a different animal. Tax consequences can be quite different depending on the structure of the strategy involved. I've seen broadly two different types. One is where employees are issued shares as part of their salary package, and the value of those shares is actually, when they vest, what we call vest, or the person becomes owner of them, becomes a taxable income in that year of issue. So that means they're paying tax on the value of shares where they haven't received cash, but they've received the shares. So how is that tax liability cash flowed when it comes to tax time? Some people, if they're issued enough shares, they may sell some of them back to fund the tax. The other type, and that's why they can be benefit, but they can be a real issue for employees if they don't understand what they're getting into. The other side that I've seen lately is more saying, okay, well, you as a staff member can buy some shares in the trading company, but you're actually making a cash investment yourself for and on behalf of those shares. And that removes that risk of the taxable income side of it, but it means that the person has got to be able to come up with sufficient cash to buy the shares. The tax consequences are different, as I said, but what we also look at is, okay, well, usually companies are offering employees shares for a couple of reasons. One is to, continuity of staff, reward on and above wages and salary, trying to get, buy-in to the view of, the trading entity. But if the shares are owned in their own name, there is really not a lot of tax benefit, because any dividends paid by the company will flow through to their personal tax return anyway. So what we have seen happening now is that a company may allow their staff to nominate an entity to own the shares. This is more complicated because, again, for the same issues as discussed with the partner agreements, is who ends up having a bit of control of those shares, and can that be dealt with as part of this shareholder agreement? So to ensure that those shares don't end up in control of someone that's not actually related to the business that's being done, and what happens in all those sort of circumstances we spoke about before, because it can be a real issue. That's why often they will have different share types that are issued. There might be normal ordinary shares, which are full voting rights, full dividend rights. There might be employee shares levels which offer access to dividends, but don't have any voting rights, and so forth. I've seen a couple lately that are trying to provide different classes of either partner or employee shares, so individually for each staff member, on some sort of scheme about trying to say, oh, well, we can pay flexible dividends, higher to some, lower to others, depending on how things go in the business. And what you've got to understand is there's a part of the tax law called personal services income. If a certain type of income can be is basically really more connected to the performance of that person in the role that they're doing as an employee, then that differential dividend really is part of their personal services reward. Whereas the normal dividends that are paid by a company are paid on the basis of overall company profit, and you just get a share of whatever your percentage shareholding is. So that is different to these differential shareholdings and differential dividend rates. My view as a professional would be I'd avoid these differential dividend ideas altogether. They're just there's part of tax law called Part 4A general tax avoidance. It's very broad, and the ATO has very strong powers to deem something to be what they think it is. Those sort of differential shareholdings would very much go down the route of being what they call tax avoidance style strategies. Because why didn't they just pay that person extra wages or a bonus as part of their salary package rather than giving them a differential dividend? So I'd be really wary of anyone that suggests those sort of things. As I said, the dividend only versus voting rights. And the reason why they do the dividend only ones is that they're trying to reward staff for being part of an organisation and working well and hard. But they don't want a complicated situation to arise where business has struggles in operational capacity because of these voting right issues. And so that's why these non-voting shares are definitely part of the employee share scheme style approach. The other issue that I've seen is, depending on the shareholder agreement and when they're issued, is what are the triggers for a compulsory buyback? Because I've seen situations where I've got a client who hasn't worked for a particular company for many, many, many years, but his agreement didn't have a compulsory buyback. So he's still getting dividends out of that company years and years because nobody's willing to pay the market rate for the shares to buy them off him, and he doesn't, he wants to be offered a certain amount to release those shares. So these compulsory buybacks are an important part of the employee share ones, where basically general rule is you leave the employee of the company, there is a compulsory buyback mechanism, and that buyback may be a share transfer between you and another employee, or it might be that the company itself pays you out for those shares and they cancel the shares on issue. And that may be relevant where you've got particular voting right shares that you don't want just lying around. So again, these compulsory buybacks will trigger other tax issues, whether it be a capital gain on sale of the shares, or it may be a capital loss on sale of the shares. So, if you have employee shares, you've got to think about this in planning moving on to another employer or leaving, is that you may trigger a capital gains tax issue in a year where you've got a lot of income, and you may be able to time yourself a bit better for where there might be some flexibility in dealing with these tax issues. So there's a lot of tax side of these arrangements that you need to be aware of. And the other one, and again, the issue here is the valuation methodologies for determining the value of those share transactions. Let's say a compulsory buyback triggered by, again, problems in employment and misdemeanors. There can sometimes be a sort of slap on the wrist style valuation where they're bought back basically whatever they're issued at. But, you know, I don't know from a legal perspective whether there's, you know, ramifications there for the company. Not the lawyer, but again, this is what we've sort of seen is situations where they might be forcibly bought back at issue price, or they're, you know, you just decided to move on, everyone's friends still, and you get a market rate for those shares. But depending on when you do it in tax year, and how much other income you've earned, or the shareholder has earned, it might be a trust, you do need to have those considerations as well. Because if you get the money and spend it on the jet ski or the caravan, and then you lodge your tax return and go, oh shit, I've got a 20 grand tax bill that I've got to pay, and I've got no cash to do it. So there's a lot of considerations there in the operation of these agreements as well, and the operation of the process of buying and selling into businesses. I think I've covered everything there. People say, oh, is it all worth it? You can get tied up in court arguing over the agreement. Well, you can get tied up in court not arguing over it, not having an agreement at all. There's better a starting point than having nothing. It's not a silver bullet, but it's, in my professional view, it's much better than not having anything at all, because things happen out of left field, like mental health capacity issues and so forth like that. And if you've got no strategy plan on how to deal with it, then what happens? And as I sat in a lawyer's office one day when my wife was buying into a business and we're sitting there with him talking about shareholder agreements and blah, 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 I said, yeah, good thing to have. But in the end, who are you getting into business with, and are you comfortable dealing with them on a day-to-day basis, and do you trust them? And, you know, things change over time, don't get me wrong. But if you're, you know, it really is about who you're getting into business with in the first place, and understanding them and who they are and potentially who they link to. You know, other issues at home can sometimes come into the workplace. So be aware of that as well. So really important there to consider the personalities, how people operate. If you can get an understanding of that, how they operate under stress as well, because if you're in business long enough, you're probably going to have some stressful situations occur. So yeah, that's probably my input here. You know, we could go on for days on these topics, but it was more to give a broad understanding of the reasons for using these documents and the importance of them. You know, we have seen situations where medical practices and someone's mental condition or premature death, and next thing, the spouse is controlling their share of the business and nobody really likes dealing with them, and it can cause all sorts of operational issues. So best to have a document that can step in and solve those problems. Thank you. That's mine. I think the next part's on to Kayleigh.
Yeah, thank you very much, Damian. That really does highlight some of the key issues to think about in terms of structuring, you know, your shareholders' agreements correctly, and, you know, the risks and things that can be involved if they're not done adequately. So from the legal point of view now, I'm going to go through understanding the different types of agreements that we've touched on just now. So I suppose some of the key considerations for actually structuring ownership effectively when setting up a company. So you've got generally two options. You can use a constitution or default provisions. However, as there may be more than one shareholder, a shareholders agreement should be prepared. The constitution and the default provisions are for single owner or shareholder type agreements, and they're not really tailored when there's multiple shareholders. So it is important to have that shareholder agreement properly drafted to make sure that it adequately reflects what the shareholders intend to be the case with their shares. So with shareholder agreements and the asset protection behind them, so basically they're put in place to safeguard the business interests, manage disputes, and also planning for the exit of the shareholder. So what happens, when one of the shareholders wants to sell their shares or leave the business. So the shareholder agreement is actually a legal document which will outline the rights and responsibilities and obligations of a company's shareholders. So, what they can and can't do as a shareholder of that business. Shareholder agreement can include bespoke rights related to particular classes of shares. So as Damian spoke about before, we can have different, voting rights related to different types of shareholder classes. Also talk about the procedure on selling shares. So what happens if we want to sell the shares in the business? Again, Damian touched on the different valuation methodologies that can be used. And obviously, that will dictate then, what method we go with to have those shares valued and what the shareholder's going to receive for those shares. And then dispute resolution, at the start, as Damian said, everyone is kosher and going to get on well, but disputes can arise, with the stresses of business and even personal life, and we need to make sure there's a dispute resolution clause to adequately dictate what will happen if a dispute does arise. We're going to look to mediation and things like that. And then what steps actually need to be taken when a shareholder breaches the condition of the agreement? They automatically, have to sell their shares, or what are the steps involved in doing so? So what should be in the actual shareholders agreement? So a well-drafted shareholders agreement can prevent future issues and disagreements. You can also include provisions dealing with how to amend the agreement in the future, including issuing new shares. And if the company does issue new shares, a new party will need to enter into what's called a deed of accession with the company and all of the existing shareholders. So that new party can be bound by the shareholders agreement, and the company can register the new party as a shareholder in the company's register. So shareholder agreement, it's going to look at the types of shares that are available. So like I said, we've got different classes potentially, and it's going to dictate, and actually define what those classes of shares are. It's going to talk about how decisions are made, including the voting rights for each of those share classes, and how dividends will be paid, and the process for getting them paid to the shareholders. It'll speak about the appointment or even the removal of directors as needed from time to time, and then how do we actually exit out of the shareholders agreement altogether. The company may come to an end, or business has ceased for whatever reason, and what happens in that case. What happens in the event of a death of a shareholder, which Damian touched on as well earlier. This does happen from time to time. I'm going to make sure that there are provisions in the shareholders agreement to deal with that. What happens if a shareholder wishes to sell their shares? So again, what valuation methodology are we going to use to work out what the cost of those shares are, and use that methodology then to pay out that shareholder for the shares they're selling. What happens if the shareholder was an employee and issued shares under the employee share scheme and they have now left the company? So talking about, exiting that company and what will happen to their shares in those situations. So I suppose then, there's, with the employee share schemes, there are pros and cons of both. We'll first look at, from an employee's point of view, what are the actual pros of them entering into an employee share scheme with their employer. So firstly, obviously, they're going to get an actual financial benefit if the company performance does well. That's going to be attributed to them helping it to do well. So they're going to have to put in the hard work to make sure the company makes a profit, which in turn will give them a financial gain. They're generally going to be buying the shares at a discounted rate as well. From the employer's point of view, they're just trying to incentivize the employee to perform well and obviously stay on in the business for a long term, journey with them. They may not have to pay brokerage fees as well for an employee, and also there can be tax benefits, which Damian touched on before. With all pros, though, there's obviously cons to the employee for entering into employee share schemes, and these will likely include limitation on when they can buy or sell the shares. So again, if you leave the company, you may have to sell the shares at that point in time. Employees may not have the right to actually retain the shares, once leaving the company, and so that unfortunately that's just part and parcel of the employee share schemes and how they work. That they're in place to keep the employee employed. So once they do decide to resign and move on, those shares will generally have to be sold off. If an employee does suffer a financial loss in the company and it does not perform well, then that's obviously going to mean that they're not going to actually gain the financial benefit that was anticipated. And as an employee shareholder, they may need to actually pay tax as well each year. Now, that's talking about the employee, but then obviously for an employer, the pros and cons are quite different. So for an employer, the pros are that they can increase the performance of the employee to ensure that they're receiving direct benefit from the company's performance. So, it's kind of a win-win. Their profits are going up, and they're going to pay a small amount to the employee for basically contributing to that as well. It can allow them to offer a lower salary. So they might be offering a reduced salary, but based on, performance, they're going to receive, shareholders' rights to the dividends in the company. If the employees are paying upfront for the shares, it can also provide some cash flow benefits for the employer from business point of view. So that can be seen as a positive for them. And it's also going to help to foster long-term employee retentions of the employees that they've got that are on these employee share schemes. And lastly, can mean that we're going to have tax benefits as well, which is always a good thing. I suppose some of the cons, though, from an employer's point of view, is that there can be significant startup and administrative costs involved, getting the right structures put in place, having the shareholders agreements and things drafted. And if the company value does decline, this could obviously impact the company morale as well. And I suppose one of the last things that could be considered a con for employers is it can reduce the control for the existing owners as well, depending on what the voting rights are of these employee shareholders. So in terms of exiting shareholders, so an employee shareholder actually leaves the company, what actually happens to their shares? So if an employee leaves the company, the shareholder agreement can dictate and require that shareholder sell either all or some of their shares. So a provision may require a shareholder to obtain prior written consent from all the remaining shareholders before it can sell or transfer any of the shares. This is often done to protect the existing shareholders from jointly owning a company with an unknown third party, which, that's not what they want when operating a business. So examples, I suppose, of exiting shareholders is what's called a bad leaver. So a bad leaver includes where there's been a defaulting shareholder that's acted to basically the detriment of the company, and they might have breached the material terms of the shareholders agreement. They could have committed an offence of fraud or dishonesty, or they might have become bankrupt or insolvent as well. So being a good leaver typically means that the shareholder is in question is basically just transferring their shares arising from a situation in which they're not in fault in any way. So I've got a couple of different examples here. So the first one is Sarah was gifted 35 plus C shares in Clips Proprietary Limited. Within 12 months, Sarah had failed to comply with the terms of her employment, and her employment was terminated. So under the shareholder agreement she had in place, she was defined as a bad leaver. So this meant that Clips were able to actually buy back her shares at the previously agreed value of $1. So that's an example of what a bad leaver is. And now if we move on to the second example, we've got Jody, who was gifted 35 C-class shares in Clips, and after 3 years, Jody decided to retire and wished to actually sell her shares in that company. So the shareholders agreement allowed Jody to offer her shares to the other shareholders at the market value. So Hunter, who was another shareholder in the company, had agreed to purchase Jody's shares from her, and the board approved the transfer, and Jody was paid the market value for the shares. So they're just two examples, of what a bad lever is, and obviously what a good lever is. Jody obviously got what the market value rate was as a good lever. So that's kind of it that all I've got to say in terms of shareholder agreements, how they operate, and looking a bit more at employee share schemes as well. If we've got any questions, I'm happy to take them from you as well. If you want to type them in the chat box, otherwise take yourself off mute and we'll give you a chance to come forward with those.
One thing I'll just add here that I thought of during Kayleigh's bit, with some of those triggers that can be, like Kayleigh broached, was personal bankruptcy of someone or something like that, but it could also be divorce, because when family assets, which include assets owned by trusts and so forth, get into the realms of a divorce settlement, you don't want the shares or control of the company ending up with the person that isn't actually involved in the company. So that can be some of the automatic levers in it, that there is either through buyback or something like that in those sort of scenarios. So, there's so many scenarios that can arise that cause problems, and if the agreement doesn't have a solution for them, then it can be quite brutal for everyone involved. It's hard to cover every potential scenario, but considering 50% of people can often become divorced these days, that's a pretty common one that comes up. And mental health is a real another regular occurrence these days, whether it be stress related or early onset dementia or things like that. There's a whole heap of health conditions now that can really cause issues for the operation of the business. So just sort of raise that divorce one because it is unfortunately more common than we'd like to think.
No, I appreciate that, Damian. You're not wrong there. Does pop up quite commonly, so it is important to take note of that. There was one question put in the Q&A section, just said, will the slides be available afterwards? So we will make sure that copies of those are emailed out. Do we have any other questions, though, that anyone wanted to raise or ask? There's no other questions. You've got both Damian and myself's contact details here on this slide. Feel free to reach out to us and ask any questions or that you may have. Obviously, important to make sure that we've got these documents in place in the first place, though. So if you are in a situation where you're in a business with multiple shareholders, then important to get those shareholder agreements drafted in place so you can rely on them should things go wrong down the track, and just making sure that they're clearly stipulated as to what the terms are. Sorry, do we have one question there?
I just was going to say your slide before that talked about constitutions and what we call our replaceable rules under Asset Corps Act. I've just come across one lately where they set it up that way with just the replaceable rules, and of course then want to bring a partner in and saying, well, now we got you can adopt a constitution and then you can create shareholder agreements, but it's another step that could have been dealt with when you first set the company up with the constitution in the first place. Extra few bucks. People try to save a few bucks and then end up spending a lot more. I just thought I'd mention that is, get some of the core documents up front, and it saves a lot of time in English.
Yeah, correct. I think it is sometimes expensive setting up a company, but you're better to do it the right way up front rather than having the problems down the track or paying extra to resolve issues. Wonderful. Well, thank you everyone for your time. Appreciate Damian jumping in and sharing all your knowledgeable information on this topic. And we will send through the slides. If you've got any questions, feel free to reach out to Damian or myself. But thank you and have a great afternoon.